Hello friends, do you know the latest legal news? No probate for will now. Yes, the Repealing and Amending Act of 2025 has done away with the requirement to obtain a probate for a will. It's time for celebration. You will not be required to undergo pain, the rigorous process, and the money spent for obtaining a probate from a court of competent jurisdiction. This is done away with. But as a matter of fact, that's not true. For all practical purposes, even though the requirement has been done away with, but still the probate would be required for all practical purposes. And I'm going to decode the Repealing and Amending Act of 2025. Section 213 of Indian Succession Act, which deals with the rights of executor and legatee, can be established through the probate obtained from a court of competent jurisdiction. This section has been repealed under the Repealing and Amending Act of 2025. It is important to refer to the deliberations of our Honorable Law Minister, Mr. Arjun Meghwal, while presenting the bill, the Repealing and Amending Bill, before the Lok Sabha. He expressly stated that Section 213 of the Indian Succession Act was discriminatory. It was discriminatory to the extent that Muslims were not required to obtain probate of a will. And he has harped upon Article 15 of the Constitution, which provided there should not be any form of discrimination. And therefore, he stated that it is important to remove this discrimination and bring uniformity. India is one country and all the communities must have one law, and there should not be discriminatory, and therefore the purpose and intent is to remove this discrimination. I respectfully submit that insofar as the discrimination is concerned, and what our Honorable Minister stated is in fact true, but it is also important to note that if the purpose and intent of removing Section 213 was to remove the discrimination only, then Section 213 should not have been repealed in its entirety. Section 213, there are two subsections. Section 213 subsection 1, which provides the authority to the executor and legatee upon probate being obtained from a court of competent jurisdiction. Subsection 2 of Section 213 deals with discrimination, which provides exemptions not only to Muslims but also to Indian Christians. And if the purpose is to remove the discrimination, then the Parliament should have omitted or repealed only subsection 2 of Section 213 and not entire Section 213. The Parliament should have taken efforts to examine the section in its entirety and should have retained subsection 1 of Section 213, which provided probate is to be obtained for the purpose of establishing rights of the executor and legatee under a will. However, that is not the case. Now, what is important is that in view of this Repealing and Amending Act 2025, most of the advocates, the people who form the legal profession, the courts, and all stakeholders would not be going for obtaining a probate, and they will have a reason that the mandatory requirement to obtain a probate has done away with under the Repealing and Amending Act. This argument may prima facie seems logical, but for all practical purposes, this may not work out. The Indian Succession Act, Section 213 specifically provided obtaining of a probate, and omission of Section 213 does not necessarily mean that probate cannot be obtained. The only difference, one may say, that now from the mandatory requirement of obtaining a probate, it is now become voluntary. But though it is voluntarily, but for in my humble submission, for all practical purposes, this would still remain a mandatory requirement. The reason is that if a person makes a will and the bequest made under a will, so far as the genuineness or the authenticity of the will is concerned, how would that be determined? Because the legatees or the beneficiaries under a will are entitled to the bequest of the testator. But insofar as dealing with those property is concerned, there may be objections to it, there may be other legal heirs who might be excluded from the will, or for transactions which may take place and under which the rights of the beneficiaries have to be established, that they have absolute rights of the property. This may create a practical difficulty in execution of those documents and transactions, because there could be, the will would be still open for challenge, and to put at rest the impending challenges to a will which may come in the future and which may further avoid execution of transactions and documents relating thereto, the requirement to obtain a probate to set at rest all questions of doubt about the genuineness of the will would be required to obtain a probate. So therefore, though it is now voluntarily, but for all practical purposes, the probate of a will still be required to be obtained. What I can say about that, in the present scenario, all communities, people, individuals of all communities, including Muslims and Christians, are now required to obtain probate. Earlier they had a specific exemption under Section 213 subsection 2, which has now been done away with. The best way to put things in the right direction is, I would make an earnest appeal to our Honorable Law Minister, Mr. Arjun Meghwal, to reconsider this aspect and to bring back in the Indian Succession Act Section 213 only to the extent that the probate of a will is required to obtain from a court of competent jurisdiction. Insofar as the discrimination is concerned, that discrimination can be removed, and I appreciate and am in sync with the removal of the discrimination. But the requirement to obtain probate, in my view, should be restored in the Indian Succession Act to put things at rest. Otherwise, there would be unnecessarily uproar, chaos in the legal profession about that. There is no legal requirement to obtain a probate for a will. Why are you insisting to obtain a